The state of New York indicted Santabello in 1969 on 2 felony counts. At first, he entered a plea of not guilty to both. After negotiations, the ADA in charge of the case agreed to permit him to plead guilty to a lesser offense. The prosecutor agreed to make no recommendation as to the sentence. Santabello withdrew his plea of not guilty and entered a plea of guilty to the lesser charge. The court accepted the plea and set a date for sentencing. A series of delays followed so that by September 23rd, he had still not been sentenced. By that time, he had acquired a new defense counsel who immediately attempted to withdraw the guilty plea. In the affidavit, he stated that he did not know at the time of his plea that crucial evidence against him had been obtained as a result of an illegal search. At the sentencing hearing, another prosecutor had replaced the prosecutor who had negotiated the plea deal. The new prosecutor recommended the maximum 1-year sentence. The defense counsel immediately objected on the ground that the state had promised his client, before the plea was entered, that there would be no sentencing recommendation by the prosecution. The new prosecutor argued that there was nothing in the record to support his claim of a promise, and the judge, who stated that he was uninfluenced by that recommendation, imposed the maximum sentence. The issue is whether a guilty plea can be withdrawn post-sentencing when a plea bargaining agreement has been broken. I don't agree with the judge's decision if he was in all actuality influenced by the prosecutor. I feel as though if a plea agreement is made, then both sides should be made to uphold their part of the bargain.